There we go. So Trudy's just messaged to say, will the slides be available after the event? Yes, they absolutely will be available. And we will send out the slides along with a link to the recording after the event. So today the employment law event is headed up by Paul Kelly and Ewan Lawrence from Black Solicitors. Paul is head of the employment team. He's most definitely known for his common sense approach to dealing with employment disputes and his focus on achieving the best commercial outcome for his clients. I've worked with Blacks for a while and they definitely have got a no-nonsense approach. It's very, very good. And then Ewan is a partner in the employment law team, and he specialises in providing clear, practical advice on workplace disputes and other aspects of employment law to employers, which are predominantly owner-managed businesses and individual employees. So both Paul and Ewan are recognised by the Legal 500, which is the world's leading legal directory. So without further ado, just before I pass over to Ewan and Paul, just to say, please remain muted, switch your videos off, it is being recorded, and if you have any questions, can you raise them on chat, please, just like Trudy has done there. And the survey will be sent out. There's a survey, a very brief survey at the end of the meeting, just with a few questions, just helps us identify how beneficial the event was. So we're going to run it as Paul will do 45, Ewan will do 45 minutes, and Paul will do 45 minutes, and then we've got time for questions, which we can address from chat at the end. So thank you very much. Over to you, Ewan.
Right, thanks very much indeed, Chrissy, and good morning, everybody. Thank you for joining us today. What we hope will be an informative and helpful exploration of the changes in employment law which we've seen in 2021, along with what we anticipate coming down the track this year. I'm going to be dealing with the past before handing over to Paul to talk about the future. And all being well, these updates should help in understanding how best to manage staff in what, without wishing to tempt fate, we might call the post-pandemic new reality. If you have any questions as we go, as Chrissy says, please do feel free to make use of the chat function. Where it's not practical to, where it's not practical to give the answers contemporaneously, we've got plenty of time at the end to deal with outstanding questions. And on screen at the moment are the areas that I intend to touch upon during my section. And so without further ado, let's just crack straight on with dealing with the end of the coronavirus job retention scheme. This is, in my opinion, the most widely discussed facet of UK employment law over the last 2 years. The scheme originally commenced, as you'll probably remember, in March 2020, at close to the start of the pandemic, and it's estimated that around 11.6 million jobs were supported. Now, whilst it's more than a little amusing to think that it fell to a Conservative Chancellor to introduce measures that seem to be taken from a socialist utopian playbook, albeit only for a temporary period, and whilst there will inevitably have been individuals who fell through the net and didn't benefit from this support, it's difficult to argue that the furlough scheme was not, for the most part, a success. For example, anticipated job losses more than halved from the 1 in 10 predicted at the start of the pandemic to now, I understand, less than 1 in 20. The scheme cost an estimated £70 billion, which represented around a fifth of the total money spent by the government in response to COVID-19. And although hailed by some, probably within cabinet circles, as the current government's biggest success, the scheme was very far from perfect. For example, the guidance was initially somewhat vague, in parts inconsistent. Rule changes were generally issued on a Friday after 5 p.m, which generally led to a frantic rush for lawyers and HR advisors to get up to speed in order to be able to advise clients. And it's also fair to say the material number of employers took unfair advantage of the scheme and the broad way in which the rules were set out. Furlough fraud is thought to have cost the government more than £7 billion throughout the lifetime of the scheme. In total, there were 3 different incarnations. The first ran from March to June 2020, and under this version, employees under any employment contract could be furloughed if there was a downturn in work as a result of COVID, and they were on the employer's payroll as at the 19th of March 2020. They had to be furloughed for a minimum of 3 weeks and were not allowed to attend the workplace or perform any of their duties, or the employer would be in breach of the scheme rules. The government contributed 80% of each furloughed employee's average wages up to a maximum of £2,500 per month, and that version of the scheme came to an end on the 30th of June. After that date, the scheme was closed to new entrants, and the second version ran then from the 1st of July to the 31st of October. From the 1st of July, the scheme would only cover the wages of employees who had previously been furloughed at some point during version 1. Employers were allowed to bring back furloughed employees part-time for what was known as flexi furlough, and the government's contribution remained at 80%, subject to the £2,500 cap until the 1st of September, where the government's contribution reduced to 70% of wages, and the cap was also reduced to £2,187.50 for the hours not worked by the employee. The third and, to date, final version of the scheme started on the 1st of November 2020, continued all the way up until the scheme came to an end on 31st of September last year. The features were similar to those of the first version, being the government returning to an 80% contribution towards hours not worked by employees, and the cap returning to £2,500 per month. Employees could either be fully or flexibly furloughed, and the government also said those who were required to shield or had childcare responsibilities due to schools having to close could be furloughed. Now, as I say, the jury's out on exactly how successful the scheme was and whether it could have been more effective. What also remains to be seen is how strict HM Revenue and Customs are likely to be when it comes to their investigations into employers who have inadvertently committed technical breaches of the rules and claimed more than they should. The indications so far are that HMRC are most interested in pursuing the really egregious, deliberate offenders rather than hauling over the coals employers who made innocent mistakes. But that may well change, of course, as the pressure increases on the Treasury to balance the books. Next up, we have a topic that was, prior to the pandemic, probably the biggest event of many of our lifetimes, but which now seems like comparatively small beer. I refer, of course, to Brexit. And at this point, I should stress that neither Paul nor I are immigration law specialists, so this is necessarily a broad brush overview. As you will recall, the UK left the EU on 31st of January 2020. The transition period ended on 31st December 2020, and so the new immigration rules started on the 1st of January last year. And as a result of the changes, the EU freedom of movement rules, which formally applied within the UK, ended on the 1st of January 2021. This meant that anyone from outside the UK, including for the first time EU workers, required a visa to work in the UK, and employers also needed to hold a sponsor license to be able to sponsor employees to work in the UK. And from that date, anyone coming to work in this country must meet skill and salary criteria laid out by the government. They must speak English, and they must have a job offer from an employer who is a licensed sponsor. Any EU citizen who arrived in the UK before the 31st December 2020 had until the 30th of June of last year to make an application under the EU settlement scheme to keep the right to live and work in the UK. Now, international companies can still go ahead with temporary intragroup transfers, but again, this is subject to the government's intra-company transfer criteria being met. And if employers are or intend to recruit from overseas, they should really familiarise themselves with their duties as a sponsor and apply for a sponsor licence. Training for staff should be undertaken by any staff who recruit and have responsibility for ensuring that the business complies with its duties as a sponsor, and hopefully that's fairly obvious. Back onto employment law issues arising from the pandemic, we had a potentially significant legislative change relating to Section 44 of the Employment Rights Act 1996. Now, by way of a quick reminder, prior to May last year, Section 44, and for that matter, Section 100 of the Act, protected employees from being subject to retaliatory measures from their employer in circumstances where they took steps relating to health and safety in the workplace, most notably notifying their employer of a health and safety risk, dealing with the health and safety risk, and/or leaving work or refusing to work because of a reasonably perceived health and safety risk. That's not the exact wording in the legislation, but that's the thrust of it. Now, inevitably, with the separate waves of lockdown and the large numbers of employers who had to navigate their way through trying to make their workplaces safe for employees to return to, there was a much more significant focus on Section 44 amongst employees, employers, and in particular, those who advised them. If we did a poll of all of you asking who had come across Section 44 prior to the pandemic, and then another for all those who were very familiar with it once the pandemic was in full flow, I envisage that the latter would have many times more votes than the former. Now, the fact that the protection was only afforded to employees and not to workers was what led to the case of the Independent Workers' Union of Great Britain against the Secretary of State for Work and Pensions and others. In 2020, following the start of the pandemic, the union received a really vast amount of questions from its members, most of whom work in the gig economy, relating to their exposure or potential exposure to the coronavirus because of, respectively, inadequacy of the PPE equipment provided to them, the failure to implement social distancing in their workplaces, and other related issues. And the union argued that not extending the protection afforded by Section 44 to workers, as well as employees, contravened two European Council directives, being, if you're interested, 89/656/EC, minimum health and safety requirements for use by workers of PPE in the workplace, and 89/391/EC, introduction to encourage improvement in workers' health and safety. Now, as a result of this landmark case, the government amended Section 44 to extend the health and safety protection to workers as well as to employees. And there is a certain logic to this move, given that, for example, Section 43K of the same Act already extends whistleblowing protection to workers in addition to employees. And it would seem pretty peculiar if a worker making health and safety disclosures that could constitute a protected disclosure for whistleblowing purposes would be protected as a whistleblower, but not potentially under Section 44. Now, in relation to the next slide, there has obviously been a considerable development in the position on mandatory vaccinations in the healthcare sector in the last month or two. And I'll leave Paul to talk about that and focus merely on what happened last year. Now, as the first bullet point states, the backdrop to all of this was the government's concern that for all that there was a high take-up of COVID vaccination programme, there was still a material cohort of the population that was electing not to get vaccinated. And this was reflected in the statistics from within, for example, the care home sector. So, whilst Section 45D and E of the Public Health Control of Disease Act 1984 actually blocked the UK government from requiring mandatory vaccinations from the public at large, it elected to instead to make full vaccination a condition of employment for anyone who worked or volunteered a CQC regulated residential care home in England, unless exempt for medical reasons. And this came into effect on the 11th of November last year. Now, whilst that was as far as the mandatory vaccination programme went in the public sector last year, there were employers in the private sector that were doing similar things. An example of this was London outfit Pimlico Plumbers, who many of you will be aware are never far away from some employment law controversy or other, which elected to introduce a much hyped no jab, no job hiring policy in 2021. This required all new employees to be fully vaccinated as a condition of getting a job. The rationale behind this was because the tradesmen and women engaged by Pimlico Plumbers would be regularly having direct contact with, and indeed being inside the homes of, any number of customers, some of them potentially vulnerable, on a daily basis, and therefore at particular risk of both catching and spreading the virus. Now, whilst there have not as yet been any reported cases that I'm aware of in respect of complaints relating to the no jab, no jab, no job policy, either at Pimlico or at other firms, it isn't hard to foresee that such a policy would come with a material risk of employment tribunal claims, not least indirect discrimination claims, given the arguable disadvantage that certain groups would be put to as a consequence when factoring in things like disability, pregnancy, age, or race, by way of example of relevant protected characteristics. Now, when it comes to existing employees, there's a whole other dimension to consider aside from discrimination, being, of course, unfair and wrongful dismissal and breach of contract. In effect, this means that employers would be unable to implement a no jab, no job requirement on their existing employees without either their consent or potentially termination and re-engagement, the ultimate nuclear option for changing contractual terms. And this is because, broadly speaking, any such measure would represent a pretty material change to their contract of employment. Now, I mentioned discrimination in regard to the last slide, and we next move on to look at developments in discrimination law relating to the menopause. This is clearly a significant issue in the workplace. For example, the UK financial services industry commissioned a report which found that women who are suffering with menopausal symptoms tend to avoid applying for promotions, and many are leaving the industry they work in altogether. Now, whilst the menopause itself is not a deemed disability as such, and does not always have debilitating symptoms, some of the symptoms that it can have, which include palpitations, joint stiffness, recurrent urinary tract infections, and difficulty concentrating, could easily be defined as disabilities for the purposes of the Equality Act 2010. Now, as a quick reminder, to be a disability for the purposes of the Act, a condition must constitute a physical or mental impairment which has a substantial and long-term effect on the person's ability to conduct day-to-day activities. So whether menopausal symptoms constitute a disability will depend on how long in each case they last and the impact that they have on the employee. Now, not only do women have to deal with the symptoms of the menopause, it's the stigma attached to menopause which can also permeate workplace culture, meaning it's often difficult to bring up the subject with an employer, which meaning in turn that most women opt to suffer in silence, or at least they have done historically, because whilst this has clearly been an issue in the workplace for a long time, the risks to employers who ignore this are increasing, as it appears to be something of a growth area for tribunal litigation. In 2018, only 5 tribunal claims referenced the menopause, but by 2020, this had increased to 16. Now, still a relatively tiny number, but that is an exponential jump and suggests that that is the way the trend is going. This risk has been attributed to the female workforce being more conscious than ever of their employment rights. And in the recent case of Donachie against Talent Technology Services Limited, the Employment Tribunal found that the claimant's menopausal symptoms, which in that case were hot flushes, night sweats up to 8 times a day, did amount to a disability, but equally, there are other cases where the findings have gone the other way. And this simply demonstrates that these cases are very fact sensitive, and menopausal symptoms will not automatically amount to a disability. If employers have staff who are suffering with the menopause, it's important that they're flexible with those employees and consider any adjustments which would make their work life easier. They should also ensure that their work environment is optimized to help ease symptoms, as this is likely to make affected employees work more effectively as they feel they're being supported by their employer. It's also wise to take care not to make presumptions about the symptoms of ill health being related to the menopause, as this can potentially constitute unlawful harassment under the Equality Act. Now, in relation to employment documentation, while it's perhaps a knee-jerk response of employment lawyers and HR professionals alike to try to address an issue like menopause through a jolly good workplace policy, provided that this doesn't represent the beginning, middle, and end of an employer's consideration of the issue, to my mind, it can be no bad thing, particularly if it encourages employees to feel able to speak about this without fear of stigma. And finally, it's also worth bearing in mind that the duty of care in relation to health and safety does have a bearing, and employers need to ensure that their risk assessments include any specific risks to employees going through the menopause. Now, onto hybrid working. Over the past 24 months, we have seen 2 separate stay-at-home orders where the UK population were only permitted to leave their homes for certain reasons. And as a result of this, many of us were told to work from home for much, or in some cases, all of the last 2 years or so. As lockdown eased, many employers decided to continue to allow or even directed their employees to work from home for at least some of their normal working week. This has represented a sea change for many organisations. Take our firm Blacks as an example. Prior to the pandemic, I had a workforce of approaching 200. I could probably count on the fingers of one hand the number of employees who regularly worked from home. Now, having recognised the advantages to both employee and employer, we've merged our 2 physical offices and encourage a default hybrid working pattern of 3 days in the office and 2 days from home each week. And I think we're probably a fairly typical example, particularly amongst professional services firms. Recent studies have found that one of the main reasons employees are attracted to hybrid working is having a better work-life balance. This can facilitate working at times when employees are more productive, whether this be in the morning or evening, rather than having to attend the office for all their normal hours. The study also said that 66% of employees say that they're worried about their health and safety, and by working from home, they are reducing their exposure to potential illnesses. Presumably that's mainly about coronavirus, but not necessarily only coronavirus. Employers may want to opt to implement a hybrid working model so they can reduce the amount of office space that's needed, as we did, and thereby reducing costs on office space potentially quite significantly. By law, employers have to undertake an appropriate risk assessment of their employees' working environment, and if they are unable to carry out a full risk assessment, for example, if the employee is working from home, then the appropriate information should be provided to the employee to ensure that they are working safely. And any risk assessments should be reviewed regularly to maintain a safe working environment. Attention also needs to be paid to the employee's mental health. Now, while some employees may welcome and enjoy working from home, for others, it can be quite lonely and isolating. Employers need to make sure that they speak to their employees and support them in any way they reasonably can. Another issue that we've found in practice is the importance of ensuring that training for more junior members of staff is maintained and kept up, whether remotely or in the office. Relevant policies should also be introduced and or updated in line with hybrid working, together with putting in place appropriate measures aimed at ensuring the employer's data and systems are kept secure and, moreover, any client or customer data. Employers may be worried about that their employees' level of productivity may suffer if they work from home. And I suppose this probably varies from industry to industry, probably not quite such a big issue in the professional services, but I can easily imagine other industries where it is a big problem. Now, although employers aren't able to monitor every single aspect of their employees' work, notwithstanding the technology that's available, they could, for example, implement regular one-to-ones or introduce key performance measures if they don't already have them. Now, just before I hand over to Paul, I've got a few noteworthy employment cases that I want to take you through. The first out of Bayfield and Wunderman Thompson, I think that's how you pronounce it, related to gender pay gap discrimination and unfair dismissal. And I say gender pay gap discrimination, this was an example of a firm that was trying to actually take action to reduce its gender pay gap, but did so in a fairly extreme way. An advertising agency at Wunderman Thompson tried to reduce the pay gap and step away from their reputation as a, quote, Knightsbridge boys club, by firing 2 of their male directors. Now, unsurprisingly, claimants issued a pretty wide range of claims, and they succeeded in claims for direct sex discrimination, victimization, and unfair dismissal. Now, this is not necessarily the end of the story here, because Wunderman have since tweeted, confirmed that they will be appealing the decision to the AT. But it is, I suppose, a warning to employers considering how they intend to reduce the gender pay gap at their organisations to think twice before jumping straight to the nuclear option. Then we've got the case of Allais against Gellen. This was one which dealing with the reasonable steps defence, or statutory defence, as is also known in discrimination cases. The claimant in this case was dismissed by the respondent due to his performance, but he went on to raise a claim of racial harassment by a colleague, and following an internal investigation, it was found that the claims were actually made out. Now, the respondents had responded to these internal complaints by making the employee in question undertake further equality and diversity training. And when the claimant issued his claims to the Employment Tribunal, the respondent tried to raise what, as I say, is generally called either the statutory defence or the reasonable steps defence, saying that they'd done all things that were reasonably possible to prevent that act of discrimination or an act of discrimination like it. So they said, well, the offending employee had received the equality and diversity training, so what more could we do? The Employment Appeal Tribunal was not persuaded by this and found that the employer could not rely upon the reasonable steps defence, as the training that the individual received was clearly stale and all reasonable steps had not been taken to avoid discrimination in the workplace. And there were many more reasonable continuing steps to take than just providing one round of training or having an equal opportunities policy. As an aside on this, in a preliminary hearing I was involved in last year, the judge did specifically comment that he had almost never seen the reasonable steps defence succeed in his practice, and he'd been practicing for several decades, which just is a bit of a sign that whilst it's available to employers, it's very, very difficult to make out. Then we've got the case of Asda Stores against Brearley. This was another long-running equal pay claim. There are many, as you're probably aware, going on with the big supermarket chains at the moment. The Supreme Court ruled that Asda workers who are based in the supermarket can compare themselves to workers based at the warehouse depot for equal pay purposes. Now, while this doesn't actually resolve the fundamental questions of whether or not the claim should succeed, it does resolve the issue of the appropriate comparators. And when making the judgment, the Supreme Court advised the Employment Tribunal to whom the claim was remitted not to overcomplicate any assessments when they are considering comparisons with other establishments and to try and avoid any further appeals. It was probably alive to the fact that from a cynical perspective, it kind of suits Asda and other large employers to keep these equal pay claims from being finally decided for as long as possible by continually appealing decisions on technical issues as far up the appellate court structure as is possible. Now, the Uber case, which is mentioned in the next bullet point, I'm sure you're all aware of. The judgment of the Supreme Court came out in February last year, confirming definitively that Uber drivers are entitled to receive national minimum wage and paid annual leave. And the judgment effectively places some limits on the flexibility of employers in the gig economy and introducing safeguards for workers, which many would say were much needed. Next case, Barrow against KBR. This is one where the claimant brought claims for unfair dismissal, harassment relating to disability, and detriment arising from disability. Now, the claimant had a rare skin condition which turned out to be cancer. The employer orchestrated a set of circumstances around the tone of his emails and other allegations to justify his summary dismissal. But when he informed the employer of his cancer status, it tries to use a subsequent disciplinary process to cover its tracks. Mr. Barrow ended up being awarded £2.5 million because it was found that his steroid medication for the skin condition severely altered his mood, which had related to the disciplinary allegations. The respondent tried to argue that his termination was a result of a breakdown in trust and confidence, but the tribunal ruled that this was actually just a cover-up. The claimant was a victim of unfair dismissal and harassment and unfair treatment from something arising from a disability. The Meyer Forstarter and CGD Europe case was an interesting one last year involving the non-renewal, of the claimant's contract allegedly because of tweets she had made, which colleagues considered to be transphobic, exclusionary, or offensive. The Employment Appeal Tribunal, overturning the decision of the tribunal at first instance, found that the claimant's gender-critical beliefs that, for example, sex is fixed and should not be conflated with gender identity, did in fact qualify for protection under the Equality Act as philosophical beliefs. Now, given the amount of coverage that trans issues is been getting over the last few years on Twitter and other social media platforms, it is not hard to foresee that this is possibly the first of many cases dealing with these issues. Finally, the case of All Answers against another related to the duration of an impairment for disability cases. In this case, the Court of Appeal held that the question when determining whether or not someone has a disability is whether the effect of their impairment has lasted or is likely to last for at least 12 months at the time of the alleged discriminatory acts. It must be assessed by reference to the facts and the circumstances existing at the date of the alleged acts. Now, I'd just like to hand over to Paul, who's going to talk you through what will change in 2022. And I will do my best to hand over control to Paul. Bear with me 1 second. Right, Paul, that's proving challenging. So if you don't mind doing a Chris Whitty, and I'll simply run you through these slides, if that's all right.
Yeah, no problem at all. Thank you very much, Ewan. Right. Okay, can you hear me? Can you hear me, everyone? Fantastic. Right, good morning. Now, for some reason, I'm not quite sure, but yeah, Ewan's still on the screen, so my video is on, so I'm afraid you have to stick with my with Ewan whilst I speak. Oh, thank you, Claire. You can see me. Right. So technical issues aside, let's crack on. So as Ewan has taken us through, there's been a heck of a lot going on in 2021, and 2022 proves to be no different. So if you look on the screen, you'll see a summary of some of the big things that we think are going to be coming up on the employment law front. Thankfully, not all of them are related, hardly any of them are related to COVID-19, although, as you mentioned, I'm going to be touching upon mandatory vaccinations, because although the government has U-turned, that has not in any way, shape or form disappeared from the public conversation. But I think a term you're probably going to hear quite a lot in my section is the phrase, as soon as parliamentary time allows. If we take our minds back to 2019 and the general election, there was a lot of talk following the Taylor report and the Queen's speech about a massive swathe of employment law reforms. And what happened? COVID happened, and the government had more important things to worry about. So a lot of what is going to happen will be, as I said, subject to parliamentary time. So we don't necessarily have specific dates of when things are going to come in. We just know that the government is intending to bring these things in as soon as possible. So jumping straight in, we will deal with the issue of mandatory vaccinations. So as we're all aware, the concept of mandatory vaccinations in CQC regulated premises was announced, and as I said, going back to what you referenced previously, that anyone who was having face-to-face contact with patients in regular in care homes mainly had to be had to be vaccinated. Now, this raised some very interesting issues, especially on the advisory side, because we had a lot of clients who were impacted by this, a lot of care homes, and it wasn't as straightforward as a lot of people thought, because referencing the Pimlico Plumbers case that you had mentioned earlier, there were some people who might occasionally need to go into care homes, and of course this led to situations where employers think, well, do we have to dismiss people just because they might occasionally go into a CQC regulated premises or not? So that was obviously caused quite a lot of issues, and unfortunately there were several dismissals that stemmed from it. But we go forward. It was then announced that the regulations would be extended under the catchily titled Health and Social Care Act 2008 Regulated Activities Amendment Coronavirus No. 2 Regulations 2021. Now, this was the regulation that said it's going to extend to the NHS in effect, and we all know what the uproar was in the press. But back in January, Sajid Javid said, actually, Omicron is not as bad as Delta, and therefore we do not think it is appropriate to extend these regulations, and what we're going to do is revoke them. Now, they had to go into a 2-week mandatory consultation, but the decision had already been made in effect. So that means that these regulations are going to be revoked. But it leaves us with two very interesting questions. The first one is, where does that leave employers who want to bring in a mandatory vaccination policy? And the answer is, it's going to be very difficult, because going back to what Ewan referenced earlier, if you are an employer that may have a mandatory or want to bring in a mandatory vaccination policy, and the employee refuses it, well, how are you going to justify it if the government has already said the health and social care sector and the NHS, who are arguably the most vulnerable in society in terms of working on the front line, don't need to be mandatorily vaccinated to protect them from COVID? How is the employer, how is an employer in the private sector going to justify it? So again, if you are an employer thinking about doing that, you're going to have a very, very good reason in which to do so. Otherwise, you could, if you proceed with it, you could open yourself up to a raft of claims, as discussed, such as discrimination, unfair dismissal, etc. The other issue that has raised, and I've had quite a few calls about it already, are for those members of care staff who are dismissed, saying, well, hang on a second, I refuse to be vaccinated. I have been dismissed as a result of these regulations. The regulations has now been revoked. What do I do? What's my claim, etc.? And at first blush, you'd think, well, hang on a second, there's got to be some form of compensation. There's got to be some form of right of action. There isn't, unfortunately, because the government said that at the time those regulations came in, the policy was correct. It was right to do so, and that, well, what they've quite glibly said is, if you were dismissed, you can apply for your job back. Sounds good in theory. In practice, it might not be so straightforward, especially as I know for a fact that when a lot of care staff were dismissed for refused to be vaccinated, should we say the atmosphere between them and their employer was perhaps not the best. The other thing is, if they do get their jobs back, they are not going to get their continuity of employment back, which means that they are going to have to work for another 2 years before they get the right to gain rights to claim unfair dismissal, etc. So that's mandatory vaccinations. So moving on to the next slide, which is dealing with workplace sexual harassment. And this goes back to 2018, when the House of Commons Women and Equalities Committee published a report entitled Sexual Harassment in the Workplace, and it identified quite a few shortcomings and failings in respect of the protections afforded to UK workers in the UK relating to sexual harassment in the workplace. So the government sort of announced that it would do several things. So it asked the Equality and Human Rights Commission to develop a statutory code of practice, looked at increasing the penalty for aggravated breaches of workers' rights, looking at whether to introduce a mandatory duty to protect workers from sexual harassment, and also looking at how best the UK could strengthen its laws. Another interesting thing, which we'll come on to in a moment, was talking about extending the time limit to bring claims for sexual harassment. So 2019, the Government Equality Office opens a consultation on sexual harassment, which is asking for views on issues, and that ran to the early October 2019, and then we all know what happened not too long after that. So if we jump forward to mid-July 2021, and the government finally publishes this response. So what it's pledged to do is a few things, such as it's going to introduce a duty to prevent sexual harassment in the workplace, and again, using that magical phrase, as soon as parliamentary time allows. And this will in effect allow the employer a defence in respect of a claim against sexual harassment only if it can show it's taken all reasonable steps to prevent harassment taking place in the workplace. So going back to what you were referencing in some of the cases earlier about putting the onus on the employer to make sure that its staff are aware of the rules, aware of the laws, and more importantly, appropriately trained in respect of preventing sexual harassment in the workplace. Going to discuss the scope for the Equality and Human Rights Commission to produce a statutory code of practice on sexual harassment, and also produce practical guidance for employers. Also to introduce a duty to prevent third-party harassment in the workplace. Again, this is when parliamentary time allows, and this is the situation where the employee might be subject to, say if someone works in a retail setting, they might be subject to sexual harassment by a customer. Obviously, you might say, well, what recourse has the employee then got? But obviously, this would extend the provisions to provide protection for that. And as I said earlier, this whole concept of extending the time limits to bring a tribunal claim from 3 months to 6 months. Now, there's two ways of looking at this. One is it's rather cynical, because if you've got 6 months, it's going to ease the stress on the Employment Tribunal Service, which is currently backlogged beyond belief. Or the more positive view is that it actually gives people more time, given the effects of sexual harassment in the workplace, to seek legal advice and get a claim off the ground. Obviously, 3 months is not a long time, and one of the things that you and I come across a lot in practice is situations where there has been for all sorts of discrimination, but even an example of sexual harassment, but because of the sensitivity of the situation, maybe legal advice has not been sought for many months, or maybe it's been ongoing and it's been a break, etc. So you do come across situations where there has been quite clear sexual harassment, but because the claim has not been brought within the right time, within the 3 month time limit, we've got time and issues to deal with. So that would actually help bringing claims to the employment tribunal. So again, this is something that we're just going to have to sort of watch this space. But the Equality and Human Rights Commission has recommended that employers take steps such as ensuring that there is a harassment policy, creating public notices that advise third parties that harassment is unlawful and will not be tolerated, inserting specific terms in contracts of employment that notify individuals of the employer's anti-harassment policies, and more importantly, encouraging employees to report harassment in the workplace when they see it. So again, we're anticipating a new statutory code in 2022, but again, when parliamentary time allows. So again, this is another watch this space situation. So moving on. So carers and flexible working. Now, carers leave has been another one of those situations that's been brought into sharp focus in the employment sector in recent years. And obviously, as we have a more aging population, especially, what we find is employees have a lot of difficulty trying to balance work commitments and caring responsibilities. And also, it does remain the situation that women do carry the lion's share of care responsibilities in the UK. So this has negative impacts in terms of work-life balance, etc. So What the government proposed, again in the manifesto of 2019, was that there would be a consultation, and there would be bringing in a right to unpaid carers leave. So what the plan was that employees would have an entitlement to take up to 5 days per year as unpaid leave to either provide care or make arrangements for the provision of care for anyone who depends on them. So in some ways, it is an extension of the existing right to take unpaid leave to deal with emergencies for dependents. But this would also be a day one right, so any new employee would have a right to it. But again, this is one of those ones where the government is going to have to wait until parliamentary time allows. So I think we're probably noticing a theme here of some of these things that are being proposed by the government. But perhaps more relevant to what we're talking about today is the changes that are going to be proposed to the flexible working regime. Now, as Ewan referenced earlier, especially with hybrid working, there's been an absolute sea change in the way we work following the pandemic, be that remote working, hybrid working, etc. And even before the pandemic, there was a lot of movement to bringing in a more sort of flexible way of working in the UK. And in 2021, there was a consultation document published by the Department of Business, Energy and Industrial Strategy called Making Flexible Working the Default. And that consultation closed in December 2021. Now, again, this sort of had its origins back in the 2019 manifesto, and the idea was to encourage flexible working as sort of default for employers. But when you hear the word default, I think a lot of people sort of get their backs up and say, "Oh, well, hang on a second, why do I have to sort of offer jobs as a default position?" And that's not really what they're saying. You don't have to sort of say that the position is default from you can choose the way you work. What it really means is that the government's trying to rebalance the current framework so people can have that discussion at the outset, rather than sort of go into what is billed as a 9-to-5 job and then say, I want to work flexibly. So there were 5 proposals that were consulted on. The first one was to make the flexible working rest a day one right. Secondly, is to make changes to the 8 statutorily approved reasons for rejecting a flexible work request, which I think, as everyone knows, broadly speaking, they can cover practically everything. You could require the employer to suggest alternatives to anything suggested by an employee. You could change the administrative process underpinning the right to request flexible working in terms of the actual requesting process, or you can do more to raise the awareness of right to request flexible working. So again, these are things that they're trying to bring in. I think what I see in practice is a lot of these things are already creeping in, especially post-pandemic. But obviously what they're trying to do here is put a sort of statutory framework to it. So I think that's going to be very interesting. Again, it's going to be when parliamentary times allows. But I think by the time it does come in, my personal view is that a lot of employers are actually going to be more accustomed to dealing with flexible work requests than they perhaps may have been in recent years. So moving on. So extensions to protected period for women returning from maternity leave. So obviously, one of the biggest concerns we have in the UK is the number of women coming back from maternity leave and then suddenly find themselves being made redundant or having their employment terminated. So again, what the proposals were, again going right back to 2019, is that the protected period is extended. So basically, it would be to the date where a pregnant lady returns from maternity leave. So what would be happening here is that before. At the moment, we currently have women have protections when they're on maternity leave against being made redundant. and they have to be offered a suitable alternative vacancy where one is available and don't have to apply for it. But again, notwithstanding those protections, a lot of women still report they don't feel that that is enough, and that their careers have been adversely affected because of having children. So what the government's recommended is that there will be enhanced redundancy protection, so that it covers the period between the woman first informing her employer that she is pregnant to 6 months after the return to work. And I think in practice that's going to make a massive difference, because what you're probably going to then see, I think personally, a massive drop in the amount of redundancies post return from maternity leave. But we shall have to see. But again, this is another one that's likely to be likely to be enacted when parliamentary time allows. So that brings us on, if we have the next slide, to the employment bill. Now, a lot of what we've covered already is sort of proposed by the employment bill, which was first raised in 2019, which seems so long ago now. And mainly the employment bill was brought in to sort of alleviate fears that workers' rights would be diluted once we left the EU. And again, COVID hit, and a lot of things just were not dealt with. So, as well as things we've talked about earlier about maternity protection, carers leave, and flexible working, the bill, when it comes in, is going to do some other things, such as they're going to bring in a single labour market enforcement agency, and that's going to be brought in to protect the rights of vulnerable workers. Don't have much more detail on exactly how that's going to be constituted, how it's going to be working, but again, that's going to be coming in. It's also going to look at the protection of tips and service charges in the hospitality industry. That is quite a big topic, actually, and that's been brewing for a while, especially when you often hear in the news there's been issues about organisations in the hospitality sector not paying national minimum wage, or using tips, or not even passing on the tips to their employees. So that's going to be quite a hot topic when that finally is dealt with. Finally, the right to request a more predictable contract if you are a 0 hours worker. So for argument's sake, if you have worked for the same employer on a 0 hours contract for many weeks, months, years, as we often do come across in practice, you are then entitled to request more predictable hours. It's an interesting one, that one, because often we come across situations whereby you have had employees who are on 0 hours contracts for the same employer for years, and actually what you find is the employee is pretty much working the same shift patterns every single week, and therefore we have fallen into an argument of custom and practice, etc. But that would again give vulnerable workers more rights against abuse from their employer. So again, we're just waiting for parliamentary time before that's going to come into force. So if we move on, the extra bank holiday. Now, this is an interesting one because what we're going to do is we're going to get an additional bank holiday to mark the Queen's Jubilee on Friday the 3rd of June. And the spring bank holiday end of May is going to be moved to Thursday the 2nd of June to allow an extra long weekend. And everyone rings me and says, well, what am I going to do about this? I've got this extra time off. Well, not necessarily. Employees are not automatically entitled to the extra bank holiday. What you need to do is remember to go back to your contracts of employment. What does the contract actually say about the amount of holidays per year the employee is entitled to and bank holidays? Usually what you'll find is a clause in the contract that says you're entitled to a certain number of holiday days each year in addition to bank holidays. Now, what you might find is the contract says it will list the specific bank holidays you are entitled to. It will say the usual bank holidays, the normal bank holidays. It's very rare that you actually come across a contract that says you're entitled to any bank holidays. So what you need to be very careful is look at the contractual entitlements of the employee before you start saying yes, you can all have bank holidays. So this is more an issue for good employee relations, and what you can do is look at maybe giving additional bank holidays, or maybe looking at, if you need someone to work, what you can do is look at maybe offering enhancements in terms of time and a half, or a day off in lieu, to incentivize employees to work. It's going to be very interesting, again, to see how a lot of employers deal with that. So, noteworthy cases that are coming up. So there's 3 cases, 2 of which actually have been handed down in the earlier part of this year, but I am still going to touch upon them. So the first one is Harper versus Brazel. Now, this is a holiday pay case. Now, this was an interesting one relating to a teacher only worked term time under a 0-hours contract, and claimed holiday pay was calculated incorrectly by the school. So what's happened here is the claimant was saying, actually, I'm entitled to more holiday. This went through the EAT, the Court of Appeal, and the Court of Appeal said holiday pay should be calculated in terms of the more financially favourable calculation. It went to the Supreme Court in late November 2021, and we're expecting the judgment at some point this year. Mainly, this is going to be of interest to schools or anyone who has term time working, but what it does is, it's found in the employee's favour. What you're going to find is that the way the holiday calculation comes, part-time workers get a slightly more favourable outcome, or slightly more favourable financial outcome in terms of holiday entitlement as compared to full-time workers. It's a bit of an odd one, that one, but definitely worth of interest. So the next one is Chell versus Tarmac Cement. Now, what this one talks about is, this was a High Court case that came out in, I think it was the 13th or 14th of January 2022. It was handed down. Now, this is dealing with vicarious liability and practical jokes at work, and it was looking at the extent to which employers are liable for horseplay. There was a bit of a nicety on this one, because one of the individuals involved was a contractor. He was the claimant. He was not actually an employee of the organisation. There was some horseplay on a site. I believe he damaged his eardrum. He lodged a claim, and this went to the High Court. And what they in effect said is that there's only so much an employer can do. So you need to do what you can to reduce the amount of horseplay or practical jokes in the workplace that could lead to personal injury, etc. But in this case, there wasn't the causal link between what the employer was doing as part of the contractor was doing as part of his work for the company, and the injury he suffered. So basically, it sort of helps an employer who says, "I've done all I can do." They were just off on the phrase employers love to use, a frolic of their own. It had nothing to do with what I was employing them to do, or the contractor was there to do. So therefore, the court agreed and said that actually it's not fair to make the employer vicariously liable in those situations. So the last one, again, this one came out very recently, very beginning of February, and it's a second dishonourable mention for our friends Pimlico Plumbers. This is another holiday pay case. And again, this is an interesting one, especially given the fact that we are post-COVID, where you have a lot of people who've got a lot of backed up holiday pay, holiday entitlement to take. And this was a situation where a bit of a nicety, because he was, there was an argument as to whether this individual was an employee or self-employed. And in this case, this individual had taken holiday, but because he was deemed to be self-employed, it was unpaid. So what happened is the court, the the courts looked at this and said, actually, we think this chap was entitled to holiday, but actually it focused more on the case of had the employer allowed this individual to take holiday, and what they found is, although he had taken holiday but not been paid for it, he had been denied the opportunity to take paid annual leave through his holiday, and the employer, in this case Pimlico, couldn't demonstrate that they'd actually given him the actual opportunity to take holiday. Now, the relevance really for employers, putting aside the nicety of the employment status issue, is this whole business of, we're all familiar with the concept of sort of use it or lose it in terms of holiday, but a lot of employers are, especially post-COVID, are coming to us saying, well, hang on, I've worked so hard, I had to keep working to keep the business going. I haven't actually had the chance to take my holiday pay. And where that is relevant is because this case is one where it says your holiday entitlement will crystallize at the end of your employment. So previously, where you might have to look at you have to go back in a very complicated calculation of when did someone take holiday, has there been a break, splitting it between European holiday, etc. So what you then do is say, actually, no, the court says the holiday pay entitlement crystallizes at the end of the holiday, and you need to look as to actually, did the employer allow the employee to take that holiday during their employment? So quite an interesting one. I don't really personally think it changes a great deal, because I think we all sort of knew that if you actually prevent your employee from taking holiday, you're going to end up in trouble. But again, it's now we now have a judgment to that effect. So if we go on to the next slide, protected conversations. Now, I'm just going to touch upon this because when we were chatting with Chrissy when we were planning this, it's something we come across quite a lot in practice, in terms of a lot of employers don't know the difference between without prejudice privilege or protected conversation regime. They don't know how to have protected conversation, and again, a lot of what you and I do is sort of dealing with situations where it's gone wrong. So what you need to remember about without prejudice and the protected conversation regime, and I think it's definitely worth remembering, is that without prejudice rule kicks in when there is a genuine attempt to settle an existing dispute. And that is the thing, there has to be an existing dispute. If we go back to some of the more, I think the leading cases area, which is Mesoterra versus BNP, you can't just pull somebody into an office and say, this is a without prejudice conversation, you didn't know this, but I want you to leave the organisation and here's a package. There has to be something. So for argument's sake, if there was a grievance, if the employee had been subject to disciplinary proceedings or redundancy potentially, you can use the without prejudice privilege because there is already a dispute in existence. The protected conversation regime, which I still think as being quite new, but actually it celebrates its 10th birthday next year, is where there isn't a dispute. And this is purely where you have issues about the employee, again, be the misconduct, be the capability, potentially redundancy, and you do drag them into an office without any prior warning or notification and say, I think we need to bring our employment to an end. One of the main differences between the two rules is that without prejudice, if you're giving them time to consider an offer, we normally say about 7 days is appropriate, but under protected conversation regime, ACAS recommends 10 days, and that really is important. Now, the limits to section 111A, which is the protected conversation regime, this is what you have to be very, very wary of. So for a start, they only apply to unfair dismissal claims. So if you're trying to compromise claims relating to discrimination, etc., or if someone's blown the whistle, etc., anything related to automatic unfair dismissal, then you can lose the protection of section 111A. What you can't do is basically say to somebody, if you don't take this deal, you are out. If you don't take this deal, you are going anyway, and you cannot put somebody under what's called undue pressure. So all of a sudden, as opposed to that prejudice rule, you have this structure whereby, while it's a very useful tool, and going back into the mist of time, one of the reasons it exists is because we got rid of the default retirement age. So really, this was brought in as a tool to help employers have conversations with older employees, I shall say, to have conversations about what are you planning on doing in terms of retirement, etc., without having the fear that they're going to be brought into an employment tribunal. Obviously, it was expanded, then we had the ACAS guidance. So if you don't follow these rules, what you can do is you can lose the protection of a protected conversation, and it can be raised, it can be brought against you in an employment tribunal. I've got a case on my desk at the moment where this is exactly what has happened. I'm acting for the employee, where somebody said something during the protected conversation where we are arguing it is clearly impropriety because they were placing the employee under pressure. And it works both ways, by the way. For argument's sake, if an employer has a protected conversation with an employee, and often you have the employee say, "This is absolutely outrageous. If you do this to me, I'm going to make it my mission to destroy you in the public perception." That's blackmail. That is undue pressure. That's inappropriate behaviour, and that can also the employee's behaviour can be rendered as admissible. So in terms of protected conversation, ACAS has given some rather helpful guidance, but what we generally say is the conversation should be as neutral as possible. You shouldn't set out that the employee is out come what may, but what you can do is say, well, if you don't do this, then we're going to have to follow this procedure, and it may result in X, Y, or Z. So the employee doesn't have to be accompanied by an ACAS, accompanied by a colleague or trade union representative, and you don't have to give them notice as well. ACAS say it's good practice, but I think what you need to be very much aware of in terms of without prejudice conversations is that you've just got to make sure that you document it. And I think from a practice point of view, you've got these 10 days. What I would always suggest is this: don't simply give somebody a letter saying, here's the offer, you've got 10 days, go away, think about it, and then we'll give you a settlement agreement. Because you're always trying to get to sign a settlement agreement. Give them the settlement agreement there and then. And the reason for this is there is nothing more frustrating. Somebody will come to, when I'm in for a claimant, someone will come to me and say, I've got this offer, they come to me on the 10th day for some unknown reason, and they've got a letter that just sets out the financials. We say, fine, okay. You go back and say, well, I want to accept it. They'll get a settlement agreement. And then what you'll find is the financials are the same, but then there's a whole other thing regarding benefits, restrictive covenants, in some cases share options, etc. So then what you have to do is you have to go back. It takes much, much longer to renegotiate. You're then looking about increased cost, etc. And all the parties end up falling out. If you want my advice, when you have that protected conversation, give them the letter confirming what the offer is and give them the settlement agreement there, especially if you want to get this done sooner rather than later, because otherwise it will just drag it out and you'll end up spending more money. But then that's my tip for the day. So move on to the next slide. Now, this is again a very topical situation. And I have to say, it's something that I am dealing with a lot at the moment. And I'd just be very interested to know if anyone listening today has come across this. Because obviously now the work from home, if you can, rules are over. Strictly speaking, the default contractual position applies. You come back to the office, but we all know in practice that is not the same. As you mentioned, we've moved to a hybrid model. But also what you're getting is a lot of employees who are saying to their employers, well, I've worked okay for the last 2 years at home. I'm quite happy doing this. I don't want to come back into work. Well, in that situation, that's where the flexible working request regime comes on. If your contract says you work here, you don't want to, you come back into work, or you put in a flexible working request, and the employee hashes it out. But what happens with some employees who are saying, I am vulnerable, I do not feel safe. So this is really what we're talking about here. It's predicated on, I don't feel safe to come into work. Going back to, if you remember what Ewan was talking about, the Employment Rights Act, this is section 100, where it gives the employee the right to say, I'm not coming into work because I perceive that there is danger that's serious and imminent, and therefore I'm going to refuse to come into work, and I'm going to take myself out of the perceived danger. This situation is very common, and it was touched upon in a first instance case, which Rogers v. Leeds Laser Cutting Limited. Now, what you had there is a situation where someone didn't have the right to claim unfair dismissal because he'd been dismissed because he wouldn't come back into work. So he claimed automatic unfair dismissal on the grounds that he'd been dismissed for raising health and safety concerns. What the tribunal did, and I must stress this is a first instance decision, so we haven't got anything more from the appellate courts about this, but it's a good indication, is they determined the difference between the danger presented by the employer's business and the risk from leaving the house. And what they said here was that the employer had done all they could do to make this business COVID safe. So they had their risk assessments, they offered PPE, they did social distancing, etc. All the things that you would expect to see. Ultimately, what it came down to is this chap was so petrified of COVID, he didn't want to leave the house. And the tribunal did distinguish it, that said, well, actually, prior to the pandemic, you weren't raising any health and safety concerns. Your concern related to the general risk that you might pick up COVID at some point in your day-to-day, I said, leaving the house. So what you've got to look at here is that what is the real danger prevented by going to the workplace? So the employer must comply with its duty to make a COVID-safe environment. If it's just a general fear, then unfortunately there's nothing the employer can do, and you may have to look at looking at dismissal. But my word of warning on this is you must make sure that you've dotted all the I's, crossed all the T's, and that you're quite confident that you can do no more. And therefore, if an employee is still refusing to come in, you can look at going down a dismissal for a refusal to come into work. But it is quite common, and again, I would be very interested to see whether anyone listening to this today has come across this and how they've dealt with it, because I think it's very easy to get the whole issue of not coming into work because of, I like flexible working, I want to do it this way, I think it works okay, and actual genuine health and safety concerns. And a lot of employers, I think, are becoming a little bit complacent in terms of the COVID safety and saying, right, COVID's over, come back to work. You don't know whether somebody is trying to pull a fast one, or someone might have they might be legitimately clinically vulnerable, and therefore there is legitimate reasons, as opposed to, well, I like working from home, I'm just going to say I can't, I'm too frightened to get the bus today. That, ironically, is quite, I hear that a lot, that I'm too frightened to get the bus, I can't come into work. So it's something that I think people are coming across a lot. So I think that brings us to the end of my section.
Thanks very much indeed, Paul. We've had a few questions come in whilst you've been speaking. I've tried to answer them as best I can, but I'd be interested in your views as well. Just to take the most recent one, Georgina asks, if we had to end an employee's contract due to refusal of mandatory vax in CQC residents and not receiving medical exemption a week before the U-turn was announced, do we have to offer the job back, or, as Paul mentioned, do they have to reapply as we weren't the information available at the time? Now, my view on that, and I'll ask for your view in a moment, Paul, is that, first of all, it's probably going to be slightly fact sensitive, so it might be one for us to have a more detailed chat with you about, Georgina. I think a lot of it depends on whether or not he's still in time to appeal, because it's only been a week. If he is, then if I were him, I'd be appealing. And unless the care home was maintaining its own mandatory vaccination policy, which it might well be, it's difficult for me to see how that appeal would not be successful, given the fact that he's only, presumably, he would only have been dismissed because of the government's policy. It's been reversed. He's appealed within the time frame after the government policy has been changed. Have you got any thoughts on that, Paul?
Yeah, I think if the employment had terminated prior to the U-turn, then he would have to apply. But obviously, if he was in some form of notice period, then I think it's a case of, yeah, he could appeal. And I suppose to some degree, a lot of it there would be a case of, do you actually want this person back? But yeah, you're right. If they had the 2-year service and they had been dismissed and they appealed within the and they appealed the notice, and you think about it, an employer, because the law that is in place that predicated the termination of employment is no longer in place, then I think if the employer didn't agree to reverse it, then I think you could potentially be looking at an unfair claim for unfair dismissal, because again, the statutory provision that predicated the dismissal is no longer in existence. So I think you would be struggling.
Yeah, and Georgina's come back to say that the option, the appeal was given, but person didn't submit one. So
yeah,
looks relatively safe, I think.
I think the key there is, did the employment terminate before the U-turn, or is it on notice? And again, it depends. Do you actually want them back? Which is often something a lot of people will say to us. Yes, they're going, but I really don't want them back. But anyway.
Yeah, and that's definitely something that Paul and I and the employment team at Blacks have observed over the course of the last 2 years, is that many employers have used the cover of the pandemic as an excuse to get rid of some bad apples, shall we say, that they've been wanting to get rid of for some time for other reasons. Now, another question which came up in relation to the maternity and pregnancy protected period, one of the delegates was asking, well, if it is extended the protected period, does that mean it will not be possible to start the redundancy process during the protected period after maternity ends? Which my view is, well, it doesn't stop you from starting a genuine redundancy process that's unrelated to the fact of the pregnancy. It just gives that person super priority, I think, in relation to alternative employment. Is that your view? Yeah,
that's my view. I think also it's in some way, it'll in some ways be like a collective consultation. You can start the process, but in effect, what they've done is they've put in a moratorium. So you can't. I mean, obviously, we need the actual statute, the regulations to be published and how it's going to work. Because you think about it, there's always going to be exemption, and there are going to be legitimate redundancy situations whereby people do need to lose employees, and simply saying, well, we've got to wait until this end of date before we can do anything, I think is not going to be practical. I think what you will find is you will be allowed to start the consultation process. You will have the I think that the term I like actually is the super priority, but ultimately it's just going to be more of a moratorium. That if the individual is legitimately redundant, that redundancy cannot take effect until the end of the protected period. I suspect there'll also be some sort of weird, wonderful provision, as there is for collective consultation, and should be in some ways, it's slightly relevant, whereby unless it is not practicable to do so, and then we'll end up having litigation on what is practicable, what is reasonable, etc., etc., etc.
Yeah, I mean, that's interesting though, isn't it? Because I mean that would represent a bit of a change to what the protected period currently looks like. Because at the moment, you being on maternity leave, for example, doesn't make you immune from being redundant, just gives you enhanced rights. So as you say, I mean, it remains to be seen what the detail really looks like.
I think so. Just on, I think it's important, because I mean, a lot of what we come across are those situations where You know, in some ways, it's not whilst an individual's on maternity leave, it's that they might be back at work. You know, weeks, if not months, have passed, and it's that case of then it's that they start seeing the move against them. So I think it's something that's definitely. I think that's really what they're trying to focus on here is to see that a lot of people are sort of hang on a second, wait till they're back, and then we'll get rid of them. And actually, what they're trying to do really is to plug that gap. So I don't think it's a bad thing at all. I'd look forward to see the actual how it's going to work in practice.
And we just had a question in which I think Chrissy herself had prior to the session starting about an employee moving abroad whilst working from home and wants to continue to work from home, but whilst being abroad. You know, what's the situation with that? Now, you know, you and I, Paul, have had pretty direct experience of that.
Yes, we have. Yeah. So a colleague. Well, so a colleague of ours, her partner, she back in June time last year announced that her partner was had accepted a job in Dubai, and that unfortunately she was going to have to hand in her notice because she had decided to go with him, and it wasn't sort of in her plan, but you know, obviously she didn't want to be alone, and it was it was something that really she didn't see any other way around. And we actually sort of said, hang on a second, why do you need to resign? Especially given what happened in the last 2 years with the pandemic. So what happened was she still works for us, but she's a home worker, and that home just happens to be in Dubai. In terms of how we did it, a lot of it is IT based, and there's a lot of data protection issues. That's probably the biggest thing we came across in terms of, because obviously you've got your GDPR obligations. So you do need to, a lot of it will depend on where the individual is going. But that wasn't that's probably the main concern we had, especially as solicitors as well. We had issues as well. The other thing that was communication. So the IT had a lot of work that had to be done in terms of just making sure that we could communicate, etc. And to be honest, if you ring our office and you speak to our colleague, you wouldn't know she's in Dubai. She won a tribunal from Dubai the other day. No one knew she was there. The other one, our tax is one. To be brutally honest with that one, our colleague in question sort of dealt with her own taxation issues with HMRC, and I think actually it was a lot more straightforward than we thought it was going to be. And I think the other one was visas, which again, for our experience, it wasn't so difficult because the way she was moving, there was actually quite an established process for Dubai, and I think she was sponsored by her husband because he was the one who was actually working in Dubai. It's not straightforward, but it's doable. And a lot of the things we our employee actually is very proactive. She'd sort of sorted these things out herself with HMRC and the government. But if you are looking at sort of moving employees abroad, then I suppose to some degree, I'd say it depends as to how sure you want to be in terms of the arrangements. Because if you think about it, they're not going to work in another country. They are just literally working from home. So to some degree, it's more their own things to be concerned about than you. What your thoughts, Ewan?
Yeah, I think you're absolutely right. I think it does depend to a large degree on the jurisdiction that they're moving to, what the local laws say, what the local tax arrangements are. I remember having a client last year who, again, because of the pandemic, wanted to work from home back in her original home of France, to be near her family rather than stuck in a flat in London on her own. And her employer did look into it, but just concluded that actually the tax issues made it far too complicated and unworkable for them to arrange. Now, could they have got round that if they wanted to keep her happy badly enough? Probably. And I think that's going to be a relevant issue for many employers, I suspect. Got another question in from Gary. Remote hybrid working, is it reasonable or acceptable to expect new hires to train in the office for a period of time before allowing them to remote hybrid working? I think very short answer to this, I think absolutely yes. I've been speaking to a client based in Wales over the last few weeks, where almost identical situation to many other employers. They were full-time in the office prior to the pandemic. Then everybody was home working, and now they're moving to a hybrid model. And they want absolutely that thing. They want the new staff who need that close contact with more senior people within the organization to be mentored, to be trained up in the first few weeks, or indeed in their whole probationary period. It's probably important for them to actually be in the office. So there's no obligation. Whilst we've been talking about flexible, or the right to request flexible working being a day one right, I do not think a tribunal is going to criticize you for saying, well, we need our new starters to be here initially. Do you agree with that, Paul?
Oh, totally. And I think actually, I get a lot of stick for saying this, but I think we're gonna have I think this has all been very secular. When we headed into the pandemic, and all of a sudden people were sort of, oh, I like working from home. I can work flexibly. I don't need to come into the office. I can do this. I can do that, and I'm more productive, etc. That was all great, and I think you can definitely do that if you're sort of long in the tooth like me and you are, and you know what you're doing. You can work remotely. You've got your contacts. You know the systems, etc. And I think what we're coming into is a time whereby people are starting to realise that you're not building cohesive cultures. You're not. People aren't getting trained properly. And I think we're going to head into a time where actually there is going to be more like, actually we do need you back in the office. Not necessarily for productivity, more to bind you to the organisation and the culture. I know we've had conversations in our organisation about how do we integrate new starters. Because we had a lot of people who I hadn't actually met for months because they joined during the pandemic. I only saw them on Zoom. So I think it's. I do think it's, as we come out of the pandemic, and whilst there will be an embracing of hybrid working, I think it's going to be totally acceptable to sort of, not just to induct people, but into the way we work, induct people into our culture. So I think it's more than acceptable, and I think, to be honest, I'd actually go so far as to say you should probably make it compulsory, because it's all very well having people all over the country, but ultimately, what's your culture like? Are you one organisation, or are you hundreds of satellite offices? I know for a fact in the law, what we're seeing at the moment is some of the big law firms from London are, and it's a term I can't stand, but north shoring their services, and they're saying to solicitors, why, we come and work for us, a big Magic Circle law firm. You don't have to ever come to London, and you can do all the work from your bedroom. And you might think, well, fantastic, I'm working for a big law firm, and I'm being paid more than I would in Leeds. But then you have to ask yourself the question, well, how is that person integrated into the business, integrated into the culture? Do they know people? And also, I think it's those conversations you have, while you're waiting for the kettle to boil and things like that they're going to miss. So I think, yes, long answer to a very straightforward question. Yeah, I think it's more than acceptable.
Yeah. Well, one thing that just before, because I'm conscious we're probably running against time here a little bit. In relation to the compulsory or mandatory vaccinations and the government's U-turn, and you mentioned, I think quite rightly that it's certainly perceived that U-turn is going to cause, or could cause, problems to other employers, the Pimlico plumbers of this world, or what have you, who want to have their own mandatory vaccination policy. But I suppose it's worth pointing out that there is another school of thought on that says that actually, in part because the government's U-turn was itself so clearly motivated and driven by political factors more than necessarily the hard science and the medical evidence. In strictly legal terms, employers who are trying to justify a mandatory vaccination policy might not be in that different a position now than they were previously. But obviously, from a perception point of view, I think a lot of employees are going to say, well, if the government have decided against doing this, why are you doing it?
Yeah, that's it. And I think it's one of those things that you might take on 100 employees and 99 of them are happy that I'm vaccinated, I'm okay, it's no skin off my nose. But there might be one who has medical reasons, might not want it for religious reasons, and that's what you've got to be. It's not a blanket ban on it, it's just you need to be careful, because if you do impose it and you don't take these things into consideration, then that's where you could come a cropper in the employment tribunal. And again, as you quite rightly said, the perception is, well, hang on a second, if the people who are absolutely on the front line don't need it because the government has decreed it, then why are you saying it? But again, private business, you say, well, this is what we have decided. It's not unreasonable, but as long as they do it reasonably. But as I said, you might be pushing against a closed door, I'm afraid.
Yeah, quite. Well, I can't see any more questions. I mean, if anyone does have any more burning questions, then please do send them in. Obviously, Paul and I are going to be available going forwards. If you've got any queries, then please just follow up with us directly. Chrissy, any further questions that have come your way?
None, and I have managed to get into the CIPD emails, so there were none too empty there. But thank you, a really informative session. What I would say, everybody, is please just do complete the very short survey at the end of this meeting. It'll automatically pop up on your screens, and we'll send everybody an email with the slides and with a link to the recording as well. And just thank you very much for attending, everybody. It's been an absolutely brilliant session. Blacks, as always, you always deliver a fantastic event. So thank you very much.
Thank you.
Thanks a lot.
Lovely. Take care,
Goodbye,
everybody.
everyone.
Bye.